As you are entering the seminar, I will start with a brief disclaimer. CLE presentations are intended for educational purposes only and do not replace professional judgment. Statements of fact and opinions expressed are those of the presenters individually and, unless expressly stated to the contrary, are not the opinion of the Florida Bar or its committees. The Florida Bar does not endorse or approve and assumes no responsibility for the content, accuracy, or completeness of the information presented. Any feedback should be provided to the event organizer. Good afternoon. Welcome to the Florida Registered Paralegal Enrichment Committee's December 12th, 2025 free CLE webinar, Notarizations and Signatures, Ethical Considerations. During the webinar, if you have a question for the presenter, please post it in the question and answer section at the bottom of the screen. Some of the questions will be answered by the presenter at the end of the presentation. Due to time constraints, there may not be time to answer all questions. At the end of the webinar, I will provide everyone with the course number, which you will use to self-report your credits in the member portal. We are not taking attendance. I will now turn it over to the FRP Enrichment Committee CLE Subcommittee Chair, Jen Finch.
Thank you, Diana. The Florida Registered Paralegal Enrichment Committee invites all of our participants today to visit the FRP Corner on the Florida Bar website, as well as our various social media platforms. It is there that you will find helpful tips and announcements of upcoming events and our monthly webinars. Our speaker today, Christina, began her legal career practicing real estate law at a prominent law firm in Orlando. After that, she joined the Fidelity family of title insurance underwriters in 2000 as underwriting counsel, where she now travels the state as a speaker. She is well known for her favorite method of teaching, storytelling, training thousands of title agents in a range of subjects from complicated case law and claims to the basics of title and closing. She guides her audiences in applying the concepts to daily practice. Christina graduated from UF Law and is a member of the Florida Bar. Thank you, Christina.
Thank you, Jen, and good morning. I guess it's technically good afternoon, Florida Registered Paralegals. Thank you for having me today. I am so excited to be here, and thank you, Jen, for connecting me to your wonderful group. So we're just thrilled to be here today, myself on behalf of the Fidelity family of companies. And today we're going to be talking about notarizations and signatures. We'll be reviewing not only the legal standards, but also we'll consider the ethical standards to which you must adhere as a notary public. And also, if you're acting as a title and closing agent in a real estate transaction, which is, of course, how I know Jen and her law firm. They are one of our agents. Now, as Jen mentioned, I've been with the Fidelity family of companies. I just celebrated 25 years with them this year, which I think is worth celebrating. So today, I will be giving you this presentation through the lens of the title insurance perspective. And I'm also going to give it to you from the viewpoint of the notary public. And if you are a notary public, it has been said, and you know this, that the notary is the last stop in preventing fraud. I have to start out with fraud, right? Because that is all the headlines. Well, one headline earlier this year declared that notaries are more important than ever with the rise in fraud, which threatens the integrity of real estate transactions. And I would say any legal transaction that applies as well. So that's where our focus is going to be today, the importance of the notary in preventing fraud. And if you're not a notary, you'll probably be reviewing documents that have been notarized. So it's just important for you to apply these concepts as well to the documents before you. Now, we're approved for 1 hour of ethics credits today. And I have been told in all my years of traveling that the ethics credit is traditionally the most boring. It wins the prize for the most boring. So hopefully you've picked up on the fact that I've tried to spice it up with a little bit. If you're picking up maybe a theme here with Mardi Gras, I know we're in the Christmas season, but I kind of went with Mardi Gras theme. And when I think of Mardi Gras, I think of music, in particular jazz music. Is anybody familiar with this song that I have? Maybe I have some musicians out there. For The Sunny Side of the Street was one of my favorites. And this jazz standard was composed in 1930, and you can see the likes of the folks who have recorded this. They are just greats. The Queen herself, Ella Fitzgerald, Louis Armstrong, Frank Sinatra. Well, if you don't know the song, it's all about making a choice. Don't walk in the shade, walk on the sunny side of the street. And that's what we want to help you do today. We want you to make the ethical choice so that you'll end up on the sunny side of the street. And by the way, we tried to get the music to play. I'm not sure that it did. I could hear it, so I was jazzing along a little bit on my side. That'll be your first homework assignment for today. If you haven't heard this song, pick one of these artists and go listen to this song because it is really a jazz standard. And I encourage you, amidst the Christmas music, break it up a little bit and listen to this song. All right. So before we explore what I have in store for you on your playlist today, I want you to take a look at what's been listened to this year on the charts from 2025 Wrapped. Now, if I have any Spotify fans out there, you know that Wrapped is a fun time of year because you get to see what you have been doing with your life on Spotify for the past year. So kudos for you all with the Florida Registered Paralegal Program because these have been your top 3 albums for this year. First of all, we have from the group Tricksters and Fraudsters, the album entitled Duping Notaries. Now, their goal with this album was simple: to get the notary to skip the requirements to have the signer personally appear or to accept the idea of an imposter by using a variety of tricks. Songs on this LP, and believe me, if you're a notary, you've heard all of these songs before. Hurry up already, or I'm just asking you a favor, or how about the Prince Charming Act, or show a little sympathy here, or maybe finally, you can just trust me, don't worry about all those requirements. Well, this one was produced by the National Notary Association. Next up, we have the album Notaries at Risks by R.E. Fraud. Now, the chart topper on this album is Getting Caught Up in Fraud Can Happen to Any Notary, Anytime, Anywhere. And a couple additional songs like Don't Be Fooled and Watch Out for Stolen Seals. Now, this album was inspired by the 2018 fraud that made headlines earlier this year, where a bogus lending company filed fake loan documents appearing to be signed by none other than Lisa Marie Presley, using what as collateral for a $3.8 million loan. I'm sure you heard about it from the headlines, using Graceland. Well, this actually occurred in theory by a Florida notary, fun fact. And the notary certificate was marked as an online notarization. But any of you that are really smart out there know that online notarization was not permitted in Florida back in 2018. Also, the notary whose name was used on those documents swore that she never notarized any documents, nor did she ever meet Lisa Marie. So in short, if you want to know the proverbial end of the story, the judge stopped the bogus foreclosure action, which was initiated, of course, after Lisa Marie's death. And just a few months ago, this woman behind the scam was sentenced to nearly 5 years in federal prison. Hence, we have this album, Notaries at Risks. All right, so if you're looking for something with a little more mellow vibes, this has like an indie feel. It's the band called Are You Kidding? Songs on this Common Mistakes album are described as being a little ballad-like and having some minor keys. And if the songs are things like Acknowledgements and Oath, who cares? What's the difference? So what if my signature doesn't match my seal? And you'll even hear some defiance in this one with, I'm not going to journal my notarial acts. All right, folks. Well, that was your 2025 wrap. So what are we going to talk about today so that we can move from all of those fraudsters to the sunny side of the street? So we have curated this list today called Making the Ethical Choice. And I'm going to tell you some stories behind some title insurance cases and claims so that you, the listener, the paralegal and the notary will learn the importance of and the value of making the ethical choice. So our playlist begins with notarization, right with the basics, the role of the notary, the requirement that the signer personally appear before the notary's duty to confirm the signer's identity, and if you are relying on a notarized document, your duty to review that notarial certificate. Again, most of these songs on this playlist will be in a minor key because it's all about people doing things incorrectly and kind of paying for that. At the end, I will take just a few moments to talk about some signatures, how vitally they are important for you to review, and I'll leave you with a few best practices as to what to look for. Now, I wanted to ask a question. I know we have quite a few people on the call today, but if you could show Diana by a raise of your hand on your little screen up there, how many of you in this webinar are notaries in Florida, which means you're notarizing a lot of documents. And while you're kind of talking to Diane magically, so that we know, I'm guessing the majority of you folks out there are notaries. But while you are talking to Diana, I want to mention that I have some written materials that are very detailed about what I'm going to talk about in the next few moments. So do not feel like you have to scramble to write a bunch of things down or to find some case law or citations. All of that will be in the materials that will be sent to you tomorrow from your Florida Registered Paralegal program as a follow-up to today's presentation. So I see we've got some people raising hands going, me. So thank you for those of you that have answered. Several of you are notaries. So hopefully this is going to be a review for you. And again, even if you're not a notary, then you can still watch out for what's happening and realize the importance of the notary. So let's get started. Let's dive right in. And of course, this is my overall theme for our whole day today. And that is the basic role of the notary. And that is to prevent fraud. Notaries deter fraud when they obey the laws governing their duties and they perform their duties with diligence. Now, all of you know in Florida, we have a notary statute. That is Chapter 117. So notaries and those people and paralegals who rely on notarizations have legal and ethical duties derived from this statute. So this is our core statute. So one of your first duties that we'll mention is you need to be familiar with this statute. And I'm not going to read it to you today, but please, really, you should review that often to remind yourself. But I'll give you a few reminders today, starting with, as a notary, there are two functions in real estate transactions that can be performed by you as the notary. That is to take an acknowledgement or administer an oath. Now, a fun fact, I know some of you also have married people before. My husband was a notary at one time, and he performed a marriage ceremony for somebody. So that was fun, but we're not going to talk about that today. So just as a reminder, an acknowledgement is a formal declaration where the signer appears before the notary and can do one of two things. They can just say, hey, I acknowledge this is my signature. They can make that declaration, or they can actually sign as a witness in front of the notary, and then the notary knows that it was them. So that is an acknowledgement. An oath is different. It is a solemn declaration accompanied by swearing that one statement is true. So just as a reminder, for a jurat, if you are taking an oath, you should have a verbal exchange with the person who is signing the document where they indicate that they understand what they are doing. And this really should be accompanied by a ceremonial act. For example, the notary may request that the signer raise their right hand and may ask, do you swear that the information contained in this document is true? And I actually think that's just kind of a best practice. Number one, to remind folks of the importance of what they are doing. And of course, that they're signing under penalties of perjury. But as well, it's a reminder for you to make sure that you are using the proper jurat for that document. For example, an oath would be for a deposition, whereas an acknowledgement is required for real estate transactions. And for a real estate transaction, in order to be recorded, we have to have the acknowledgement, not an oath. So an oath would mean you got to go back and get an acknowledgement. So here's what the acknowledgement would look like. This language, it must have the language of this foregoing instrument was acknowledged before me. And the oath has that sworn to language, sworn to or affirmed and subscribed before me. So let's take a look at the importance of the distinction between this acknowledgement and the oath and how to apply that. Now, you all know that Florida law requires both an acknowledgement and an oath to have certain elements, certain requirements must be met. And the first is that the signer personally appear before the notary. Sometimes people refer to this as the presence requirement. I think this is one of the most basic requirements in you performing a notarization. So a few points to consider on this and as review for you. The signer must be present at the time of notarization for either an acknowledgement or an oath. And to evidence that, that acknowledgement or jurat may contain a statement that says, signer personally appeared before me at the time of notarization. And that can be by way of physical presence or by way of AV communication technology, which of course means remote online notarizations, which goes beyond the scope of today's topic, but it is included in there as a way of meeting this physical presence requirement. So to state this in the negative, the notary may not notarize a signature on a document if the person whose signature is being notarized is not in the physical presence of the notary at the time the signature is notarized. Now, I want to make a quick distinction here because many people misinterpret this presence requirement, and I don't want you to misinterpret the presence requirement. They incorrectly believe that the presence requirement means that a document must be signed in the presence of the notary. Signed. In other words, they think the notary has to witness the document signing. Well, in Florida, a notary may also be a witness, but they are not required to be a witness. So what does that mean then? It means the alternative is that the signer could just appear before the notary and acknowledge his or her signature at the time of notarization when you put your stamp on and notarize it. So for example, simple example, I sign a document in my home. I go to my bank and I talk to my banker and I say, hey, can you notarize this document for me? I acknowledge this is my signature. They can notarize that document because I have appeared before my banker as she is notarizing it, and I have acknowledged it, even though I'm not signing it in her presence. Now, I will say this. I want you to understand that distinction. But for title purposes, for what we do in real estate, and probably for what you're doing in this day and age of fraud, we don't particularly favor documents that are brought in and saying, hey, this has been signed before. I think you can see where this is going, even if you're not in real estate. Here's my ex-husband's or my soon-to-be ex-husband's signature on this document. We don't really want to rely on documents that have been signed outside of our presence. So we usually see in our industry where the notary serves as the notary and as the witness. Of course, when the notary is wearing two hats, that means there should be two separate signature lines, one in the notarial certificate, and of course, one up in a different area as a witness to the signature. So two separate signature lines. Now, also a reminder, failure to adhere to these statutory requirements could result in civil and criminal sanctions for the notary, as well as disciplinary proceedings for any attorney who supervises the notary. So speaking of attorney disciplinary proceedings, let me share an interesting story of one in particular. So we're going to look at the Florida Bar News disciplinary actions. Now, this one's an old one, but it was too good for me not to share with you. It's from 1992. And again, it relates to this most basic and, in my opinion, important requirement. The Florida Supreme Court held that soliciting improper and illegal conduct of a notary warranted a public reprimand. So the facts in this case were very simple. Some documents were returned to the representing attorney with signatures that lacked the required notarization. So the attorney, what did this good attorney do? They went to their employee, she was probably a paralegal, and asked her to notarize the documents. So to recap the basic facts, in the room, we have the attorney boss, partner probably, the notary employee, paralegal, and the documents. Who is missing from our fact pattern here under Florida law? The signers are missing. So the Florida bar then charged this attorney with violations of the rules. And the court correctly interpreted the Florida law that I just went over with you that says while the signer need not actually execute the document before the notary, aka be a witness, the signer must personally appear before the notary at the time the signee acknowledges that he or she executed the document. Now, what was most interesting to me about this case was how the attorney responded to the allegations against him. So first, he claimed, I didn't know that the signatures had to be witnessed by the notary when she notarized the documents. Did you catch that there, folks? As we just reviewed, that's actually a legally incorrect statement of law, right? Stated correctly, the signers had to appear before the notary when she notarized the documents, not when she witnessed the signing of the documents. Well, from there, his second argument was the classic. This was the classic. You have teenagers, you've heard it. Everyone's doing it. And this is a direct quote. The practice of finding a notary to notarize a client's signature without the client being present seemed to be fairly common among members of the bar, even if that practice was not ethical. What do you think about that, folks? Well, at least this argument accurately sets forth the presence requirement. But of course, the attorney's actions still failed the test despite this argument, which I think is a terrible argument, by the way. His next defense was that his actions were lawful and reasonable under the facts of the case. He actually made this argument that there was an exception to the statutory requirement, namely, he believed he had satisfactory proof of the signer's identity. You know, I know these clients. They're good clients. I talk to them on the phone. I know this isn't a fraud. So I guess the argument is I fulfilled that basic role. So why do I have to meet these, nitty gritty statutory requirements? Well, there's an exception for me, even though it's not in the statute. Again, not a good argument. Finally, this one is dedicated to all you notaries out here. His last argument was, even if the statute was violated, my actions were not unlawful. If anyone's acts were unlawful, it was who? Who do you think was unlawful? Whose acts? Well, the notary. This is the classic throw the notary under the bus argument. So what is the moral of this story? There it is. Don't be this guy. Don't be that guy. Even if he really kind of only did get a slap on the wrist through the disciplinary actions, we have this case to learn from. I mean, these are the arguments that people make to you all the time and the pressure you are put under. So the takeaway for you as notary publics, if you are a notary public, you must adhere to this statutory presence requirement, even if your boss asks you to violate it or your clients pressure you. I don't have time to come back in the office and appear before you. I'm really busy. Or if your colleagues tell you it's just one time, no one will know, right? Because the document hasn't been recorded. So no one will know this happened. Or how about this one? It's for a really good client. Well, the other thing to learn here too is some of you in the audience may be a manager or a supervisor or an attorney who supervises the actions of your paralegals or even a notary public. You should remind your notary of the statutory presence requirement, and please authorize the notary to decline a notarization if the requirements are not met. Again, don't be that guy. I'm guessing this may have happened to some of you in the audience. In fact, it happened to me when I was in private practice. So it is a tough situation, an ethical dilemma, I will say, an ethical dilemma. So please adhere to the statutory guidelines. If you email me later, I'll tell you my story and how it ended. For another day. All right. So another example of a notary failure, but this time I'm going to go one step further and ask the question, can the employer be held liable for damages due to the notary's misconduct? Well, this case was decided by the Florida 5th DCA, and the notary failed in her obligation, which the court stated was simply to either know or have properly identified the signers who appeared before her and then administer the oath. Now, of interest in this case is that both the notary and the employer, a law firm, were the defendants in the case. In other words, notary and law firm employer were both sued in civil court for monetary damages from an improper notarization. So the court, in short, held that as to the claim against the notary's misconduct was too tenuous to be the proximate cause of damages. But as to the employer law firm, they also held there was not enough proof that the notary was acting within the scope of her employment. So let me give you a few nuances of the case. Well, first of all, it was undisputed in this case that the mystery signers never appeared before the notary at the time of notarization. The court even stated as such. There's no doubt the notary statute was breached by the notary. And by the way, this is why you adhere to the statutory requirements. You never want to see this written about you in a court case. All right. So again, the basics, the presence requirement was not met. And the court mentioned that the notary's failure to administer the oath was part of the fact pattern. Now, I did want to kind of pause for a moment to think of an idea implicit in this statement by the court that the notary failed to administer the oath. It's impossible to administer an oath if someone doesn't appear before you. I mean, I guess you could do it over the phone these days. But this shows the importance of that ceremonial act of going, raise your right hand, because then you can make that part of your everyday practice and you can rebut any argument against this in the future. And you go, this is my practice. I make them raise their hand and I make them repeat after me. So it's just another step to ensure that you have met the requirements. All right. So let me fill you in on a few facts of the people involved. So the documents in question claimed that two men, you might recognize a couple of these guys, Sammy Jr. and Dean, they were the agents of this insurance company, a bonding company, and the notarized documents were bogus. Okay, so that is the bottom line of this case and where this whole litigation started. So the short story is the plaintiff paid like $70,000 in premiums for these bogus bonds. And supposedly in reliance on these documents, because they were fake, they lost a contract with the state of Florida to get the deal. So these bonds, and probably the fraudster who drafted these fake bonds, were spearheaded by this guy named Frank. He was the leader of this rat pack. Well, he served as the broker for the deal, and it was old Blue Eyes himself who asked the notary to notarize the fake documents as a personal favor. You know, there's that Prince Charming again. Let me also mention that a default judgment was obtained at the trial court level against Frank to the tune of $350,000. So My argument is the plaintiff was made whole at that point. However, there are still two defendants left in this case. Reminder of who they are: the notary and the law firm who employed the notary. So let's take a look at what happened in the case. Beginning at the trial court level, circuit court granted summary judgment in favor of the notary and the law firm. Now, I am not a litigator, but I'm pretty sure I recall that a summary judgment is a slam dunk right out of the case, right? They won. Well, not so fast. Plaintiff appealed. So in 1996, Fifth DCA held there was an issue of fact that remained, reverse summary judgment, and then it goes to trial. And this was an interesting quote by the court, and it is a good quote. So remember this quote: "If business cannot depend on notaries doing this simple task, then there is no place for notaries in the world of commerce." Pretty strong statement, but again, we're going back to these basic requirements. Well, the issue of fact that remained was that the plaintiff alleged he relied on the notarization as confirmation that the rats actually signed the bonds. So that should give us a question too of really what is the scope of the notary's role in this? Now, I want to mention the dissenting judge was all over this, and he basically gave us some more facts, which I'm going to share with you because, again, this just really fills out how difficult it can be, how much pressure can be put on you as a notary. So in this case, the notary was the runner in the law firm, and Frank's wife was a secretary of the senior partner, and the notary and the runner notary and the senior partner secretary were good friends. And Frank comes in with a bunch of documents clipped together and had a bunch of flags, and the notary runner probably didn't have much experience and thought she was notarizing Frank's signature, not Sammy Jr. and Dean's signatures. So the dissenting judge mentioned that holding the notary liable for damages resulting from any breach of duty, however remote or tenuous, would in fact make the notary the insurer or guarantor of the document and its authenticity. And that is an issue that I know sometimes you struggle with. And we see this sometimes in our real estate documents too. And just to go in the weeds a little bit, to toss out something for you, real estate paralegals is in the notary block, when we have somebody signing on behalf of an entity, sometimes people quibble over that language because the notary says, hey, I don't want to be in any way implying that I'm ensuring that this person actually is the manager of this LLC. I just want to sign that they appeared before me. So that's a little bit of a nuance on this as well. But anyway, in short, in this case, this dissenting judge said, hey, this is just too tenuous. These were just bogus bonds. It's not the notary's fault, okay? Which I think is pretty good logic. So the case goes back to civil circuit court, 3-day trial, which is your worst nightmare, right? Is to having a jury trial. Well, directed verdict again in favor of the notary and law firm. They won again. What do you think happened next? If you were live, I'm sure the whole audience would be screaming, they appealed. Well, you're right. They appealed in 1999, back at the Fifth DCA. This time, the dissenting judge wrote the opinion, which affirmed the directed verdict in favor of the notary and law firm. So basically, the whole gig was that Frank previously had done this scheme and gotten away with it. And the real problem and what this dissenting judge, or the old dissenting judge, who now was the judge writing the opinion, the real problem was not the improper notarization, but the fact that the bonds were no good, that they were bogus. The notary failed in her duty, yes, but she was a, to quote, small cog in the wheel of fraud. So another win. Well, kind of, because of course they took it to the Supreme Court all the way in 2000, where they denied review. So what do we learn from this? Well, first of all, you never want to be in this position. And you all know this better than anyone else. You do not want to be in litigation. I don't know what the failure was caused by, a mistake, inexperience, ignorance, but you do not want to be defending this lawsuit and losing sleep. Because any of you know that if you've personally been involved in a situation like this, where it basically goes against your reputation, it's very challenging. So again, we also learn, I want to remind you, under the Florida statutes, the employer of the notary can have potential liability for damages caused by the notary's misconduct if they're acting within the scope of employment. I have those citations in your materials. So again, I hope I've made for you a compelling case for the importance of the presence requirement. All right. So moving on to our next song in our playlist, and that is the duty of the notary to confirm the signer's identity. Now, I've already alluded to fraud, but what we are seeing in real estate is seller impersonation. It is happening widespread in the real estate industry. It is, of course, I'm sure you've seen making national headlines. Now, there are many ways to verify a seller's identity, but today our focus is going to be on the notary's role in every transaction under Florida law. And that notary will be possibly under your supervision as one of your employees, or sometimes that notary will be unknown to you and you're reviewing the notarial certificate. We see this in real estate a lot when we have mail away closings where we send documents out, which means the employee of our law firm agent is not acting as the notary. So much more heightened risk in those situations. So now more than ever, you have to properly supervise the actions of the notary to prevent a fraud and title claim. Now, I did want to mention briefly, talking about title claims, a quick statistic for those of you in real estate, and I think it will help you even if you're outside of real estate. The American Land Title Association completed a study of costs to resolve title claims over a 10-year period. I think it went up from 2012 to 2023. But they found that the title insurance industry paid $5 billion in losses for claims reported in just that decade, that 10-year period. Now, of interest for us today is the finding that 20% of those dollars were spent for fraud and forgery. 1 out of 5 of those dollars was on fraud and forgery. And to boot, fraud and forgery claims are 5 times more expensive than just a regular title insurance claim, like a lien, an outstanding lien that was missed, or a missing mortgage. Those types of standard claims in title insurance average about $26,000. A fraud and forgery claim averages almost $150,000 per claim. So they are not only rampant, they are big dollar claims. And your role as the notary is really important in preventing fraud. So I do want to encourage you with that hopefully this is a review for you today. Keep up the good work, okay? So when we're talking about the signer's identity, Florida notaries may not notarize a signature on a document. This is how the statute reads, unless the notary personally knows or has satisfactory evidence that the person signing is the person described in the document. So in other words, the notary, if you're the notary, must confirm the person appearing before you is who they claim to be. That can be evidenced one of 2 ways. And again, I'm mirroring the statute here. Personally known means having an acquaintance derived from association with the person, which establishes the signer's identity with at least reasonable certainty. Now, this satisfactory evidence test is another 2-part test. First, the notary may reasonably rely on an approved identification. In Florida, in our real estate transactions, we most often see a driver's license or a passport, but there are others such as identification cards that qualify under the statutes. So there are some practical steps that you as a notary can take when you're relying on an ID to make sure that your reliance is reasonable. For example, the ID should be current and issued within the past 5 years. Our agents are not to rely on an expired ID. Must have the qualifying identification numbers, the proper security features, which you can go online to any of the 50 states to see what a real, authentic driver's license should look like. And I will say I've been doing this for 25 years talking to our agents. I used to say, touch and feel the doc or your ID to make sure it feels legitimate. We are way past that these days. We are using software providers to confirm seller's identification, but still, what you do in the presence of that person makes a big difference because you're the one that's going to see the red flags and go, hey, this doesn't seem right. Okay. I did want to mention as well, Lee County has a title fraud prevention pilot program that they actually require copies of the ID before recording. And that pilot ended earlier this year. They're doing a report right now to release to see if they're going to spread it to all of the counties in Florida. And I have heard that simply by requiring ID, there's some anecdotal evidence out there that they were looking at people in recording offices. And when they said you had to have IDs, literally people would hop out of the line and just give up on recording it. So we all need to work together basically to prevent the fraudsters, or at least make it harder. Like, go find an easier target. Okay, so the second part of this test is there is an absence of information or other circumstances that would lead a reasonable person to believe that the signer is not who they say they are. So questionable circumstances could be things like, we've seen all of them. We've seen somebody that looks 75 years on their picture and they come in and they look like 24 years old. I mean, there is some magic happening out there, folks, but I'm not sure that can happen. Misspellings where the signature is spelled differently than the spelling on the ID. We see that a lot. Person's date of birth doesn't match other information. So if you find any information that's contradictory, then at that point, you at least need to pause and you need to readdress what's happening here. So again, failure to abide by these statutory requirements that are right in front of you is a legal and ethical violation. You can have your notary appointment suspended or revoked for neglect of duty. And you can be guilty of a third-degree felony with criminal sanctions. And from a real estate perspective, practically, that failure may result in the fraud. It may be a fraud by way of a forged deed or mortgage. And in that case, civil penalties can be assessed against the notary public. So that's based on a negligence claim against the notary. So let me give you an example of that. I'll just give you an overview of this case from the 4th DCA. And this one, I'm not necessarily sure I agree with the judge's findings and conclusions. So the court reinstated a jury verdict against a notary, holding that the recording of this fraudulent deed was the cause of the estate's damage, the plaintiff's damage of almost $250,000. So the short story is there was a deed that this deed in question was truly a forgery. So what's interesting is the court's finding on causation. They basically said that the notary's failure to properly identify the person signing the deed, so the fraudster in this case, caused the damages to the estate. So what exactly is this claim of negligence? What did the notary do? What standard did the notary fall below? Well, the notary had no memory of notarizing this fake deed. She admitted that she failed to record the driver's license number of the signer, even though that's what she usually did. And she admitted that there were differences between the signature of this fraudster and the signature on the driver's license, which, funny enough, when I went to vote in my local city commission, I kind of scribbled, because you know how you scribble these days when you check out anywhere to do a signature. They made me re-sign, and we're looking at my driver's license signature, which is really hard to do on the little pads that you do. But really interesting that they had me re-sign, because that was an argument here. They had a handwriting expert that testified at trial that the signature on the deed was not the true owner's signature. So the appellate court said it's irrelevant that the deed was forged and didn't pass title. I disagree with that conclusion. And it was based on the fact that the notarization was what allowed the document to be recorded under the Recording Act. So again, lower court said a forged deed is legally insufficient to transfer title. If the deed's void, then the action of the notary is no consequence. I agree with that. But again, that's not what was held in this case. So what do we learn? Well, again, I will remind you, a lot of time and money was spent in defense of this case, only for the notary to lose and pay. Now, I personally think that the court placed an improper burden on the notary as to causation of the damages, because the question is, did the faulty notarization really cause the damage here, or was it the forgery? Okay. Well, anyway, I don't have specifics as to how the fraud went down and how this forgery transpired. But again, I think this tells us we need to institute policies and best practices so that we avoid this situation. And I did want to mention again, I love my real estate, people. I have loved it ever since my second year at University of Florida Law School when I had my real estate finance class. I loved it. So I got to tell you a little bit more about real estate. The revised American Land Title Association best practices, which is basically our organization or association that advises us with all of the latest and greatest things to do. Well, their best practices were just updated in August of 2025. If you're a notary and a practitioner in real estate, you need to be looking at these best practices. But they basically, because of all of this seller impersonation we're seeing, they have updated their identity verification protocols to prevent identity fraud, which is what this case was here. And they drilled down into things like controlling the selection of the notary, which of course, for like a mail away closing, you have to be very diligent. And, we have people that go, oh, I want to use my own notary, not your notary. Well, that's not going to fly anymore these days. And we have stories about how people have been duped. So just know we have to be in control of the notary to know that they are legitimate. Also, we have some different ways of confirming proper, valid identification, different ways that can be done using new technologies where you can verify the identification, so that it's not all just on you looking at an ID. So again, another thing they mention is any documents that are notarized by a non-employee are just out of the gate considered at-risk documents. So you just treat them as a higher risk document. So if you are in real estate, the question is, have you read those updated guidelines and are you following them? Okay, so that leads up to the question of what is the duty of care for the notary? So I want to dig in for a moment and consider a few practical tips for you. The court in that last case relied heavily on a law review article for the basis of the findings for the notary's negligence. And they basically said the notary must act reasonably in the performance of every notarial procedure, including the responsibility to verify the identity of every person for whom he or she notarizes. Also, according to that article, the notary is liable to all persons who suffer injury as the proximate result of the notary's breach of care. So if you're looking for some more information than that, I know you have access to numerous resources, not only through the notary associations, but even through the Florida Bar. But you should be referring to these frequently. Of course, we have the governor's reference manual. The latest version, I want to say, I'm not sure if I double checked this one, but I think the last version was 2019. That can be found at flgov.com. Another resource for you is, this one is really great. We're talking about ethics today. The Code of Professional Responsibility by the National Notary Association. This was just recently revised in 2025. I hazard to say they'll probably be revising it again because of all of the fraud out there. And a couple of examples that they go into explaining more about how much you need to know the person to personally know them. It can't just be like met them once right before your closing transaction. You have to have a little more substantial and meaningful and interaction with the individual. So again, drills down on some of those requirements. And then I also found another interesting article that was entitled "The 10 Commandments for Lawyers." Insert lawyer joke right here. There could be several good jokes right here. But basically, this was taken from an article in 1999, but these are still some really great practices that you can do. Study the statutes. In Florida, you're not required to keep a journal, but it's a good idea because you can use that if you ever need to defend your actions. Again, physical presence. Have a policy for identification and use it every single time. Never take shortcuts, and establish a prevention program. Also, I would say too, is just, you got to just not fall into the pressure of these folks that are asking you to potentially violate these. So I did want to mention also reviewing the notary certificate, the notarial certificate, because again, we've already mentioned that there are requirements under the statute for the acknowledgement or for a jurat, things like, the venue, the state and county, which type of act, acknowledgement or oath, personal appearance, date of notarization, the type of ID, all of that stuff. But under the Recording Act, this deed or mortgage for our purposes in real estate has to be acknowledged, as I've already mentioned, to entitle it to be recorded. So there's an ethical duty and a legal duty to review this notarial certificate. So I'm going to give you an example of a happy tune, because I don't want you to think I'm a Debbie Downer with all of my stories of failure. So this is a happy tune from one of our agents when life was really sweet on the sunny side of the street. So this was a for sale by owner where a deal was brought into one of our agents' office to close. So this woman says, I'm selling my home because someone broke in and ransacked it. I left so quickly, I didn't even take my purse, which had what in it, ladies? My identification. Well, I never want to step foot in that house again. The agent noticed when this call came in that the caller ID had a different name than who this seller claimed to be. First red flag. Well, the contract, this is one of the frauds that we're seeing, called for an early release of the deposit back to the seller. But the seller wanted the funds to go to her friend's account. I had to close my account down because of this robbery. Well, our agent was smart enough to say no can do. Well, then the seller says, how about we use Venmo? Okay, right there, I think we should just call it quits. The answer is no, which of course our agent said, nope, can't do that either. Then this is what happens to our agents all the time. Well, I'm just going to take my marbles and go home. I'm going to go somewhere else to close my transaction. And many times we tell our agents, if they're saying that, then let them go, let them off the hook. So the agent says, hey, buyer, there's a lot of red flags here. I don't think we should release the deposit, but the buyer authorized the release of the deposit. When it was time for closing, the seller would not allow for use of the approved notary, which we have requirements within our Fidelity family of underwriters for approved notaries for certain transactions. She says, I'd only feel comfortable with my friend serving as the notary. Of course, our agent, being diligent, says no can do. As a compromise, your friend can come to the notarization, but she cannot act as the notary. Nope. Seller says not going to do it. So the agent warned the buyer again, lots of red flags. Well, this seller then pulls out the big guns. I've talked to your competitor. I'm going to take my deal because they'll rely on my friend's notarization. So I said, hey, our agent said, let it go. Well, unfortunately, that new agent failed to review the notarial certificate. 2 weeks later, only 2 weeks after closing, the buyer contacted our agent, letting them know the new agent did not confirm the notary was valid. She did not verify the notary's appointment. The stamp was completely fraudulent. And as you guessed, the seller was an imposter. Interestingly, the buyer had already removed everything, ripped out the kitchen, started rehab, and then it was discovered by the real owner. I'm guessing if they had an owner's policy, that would be a claim under their title insurance owner's policy, but it was not one of our agents, so it was not one of our claims. So it was a good ending, a happy tune on the Fidelity side. Now, I do have several best practices coming at you tomorrow in your materials for evaluating the notarial certificate. So I'm not going to read through those for you today. They'll be in a list form for you tomorrow, and you can always reach out to me as well if you have any questions once you review that. But overall, remember that no one can override the notary laws, not an attorney, not a customer. We even tell our agents, not even us as an underwriter, if a statutory requirement's not met, you can't notarize the document. So you need to be willing to decline even when there's a lot of pressure. And I dare say these days, folks, if there's that much pressure, that alone is a red flag that maybe we're dealing with a fraudster. So I'm going to wrap up with this very short point on review of signatures, because we know that everything is moving at a record pace and it's hard to keep up. We're dealing with digital documents, but there's still something really important about signatures. And by the way, I still like a good old school closing when we're talking about coming to the office and signing your name and having a little popping of the champagne. I think we should go back to that way of doing that. Now, I want you to remember, if you're doing that, it's important to compare signatures. We have many stories of our agents who have stopped a fraud simply because they've noticed that a signature looks really off, and they do some questioning. And of course, the answers go from bad to worse. And we realize that this is, in fact, a fraudulent situation. So I share, let me share this information. You can see here some examples of comparing signatures. This was a woman accused of and charged in Michigan for a nationwide mortgage document forgery. So you can see by the time we get to the bottom, clearly this should at least have a question. Now, I tell our agents, you're not required to become a forensic expert on handwriting. Although if you did, I might think that would be a cool job to have. But I think even just generally, you could tell maybe this should deserve some questions. Now, I've been using this image, I think, for a decade because it is just so good. It's a little grainy, but it's so good I needed to share with you. On the left, we have a genuine signature, and we can see, I'm guessing with AI, we can work on skilled forgery. Although I did try to get you an AI forged signature, and it would not do it for me. That was interesting. But anyway, you can see the difference we're saying, if you can see the difference between the left-hand side and the right-hand side of this screen, then maybe you should ask some questions. Another thing I wanted to point out too is beware of misspellings. We see this often. That is an indication of potential fraud too. Misspellings in signatures, in the notary signature, if you're examining a document that has been notarized and the stamp has a different spelling than the signature, that is a definite red flag. Compare the spellings between documents. Look at the ID. We actually had an agent avoid a fraud because there was a misspelling in a street address. So again, beware of those details and be willing to ask questions. Was this just a mistake, or is this potentially a fraudulent situation? So I will leave you with a couple of practice tips, a couple of things generally you should do. And again, the materials drill down deeper in this, but you should contact the party directly. Usually by phone is best, not by email, and then independently verify their identity and their signature. And when I say independently, don't rely on an email that was sent to you. Another thing we see a lot is business email compromise, where the fraudsters inserted themselves into your transaction and they send a fake email with a fake phone number. Don't use that email. Use one from a prior transaction or from a website. Independently obtain contact information to verify it. Also, another thing that we're seeing, and the FBI actually recommends this as well, is request 2 forms of ID prior to signing. Don't give them time to create those. Like you say, I need 2 forms of ID in 5 minutes, then evaluate it. These should be scanned color copies. The FBI says scanned color copies, no copies of a copy. Photos should be well-defined and not blurry, no smudges or different fonts. Compare that information to open databases to confirm things like their age, their place of residence, to see if all of that matches. Beware of new pages. Like if they try to create a fake social media page and there's only like 5 friends and 2 posts, then that's a red flag. Schedule this video call prior to any signing. Then you can compare the ID in front of you to what you're seeing on the screen. And of course, you've probably already seen this. This is the new way of authentication for documents, is you have to actually do the selfie where you take pictures of each side of your face for the biometric identification. Well, that's where we're getting to these days as well, prior to signing. Of course, also there's some do nots. Do not rely on information that was provided to you as part of the transaction that is in question. So again, don't rely on the contact information from what is a questionable email. Also, again, I've mentioned conduct your own research, look for Facebook pages or other open databases to verify they are who they claim to be. And then most importantly, I'm just going to end with this real exhortation for you is to trust your gut. Do not proceed with, in real estate, a closing or a transaction or wherever you are in your day-to-day operations until all of your questions have been satisfactorily answered. Most of the time, what we find with our agents is that when directly questioned, the fraudsters will take their bogus deeds or their bogus deals, or whatever it is, mortgages, and they'll go to an easier target. So I will close today because I see that we are at time, that we want you to walk on that sunny side of the street where you have a successful closing. So at Fidelity, F&F Florida agents, if any of you are out there, we wish you success in all your closings and your notarized documents. And we hope that you end on a happy tune on the sunny side of the street. So I will turn it back over to Diana. Thank you all for having me today. I hope we had some helpful information for you.
Thank you so much. Thank you, Christina. Thank you all for attending today's webinar. The course number for today's webinar is 9320. Again, the number is 9320. This webinar has been approved by the Florida Bar Continuing Legal Education Department for 1 hour of general, 1 hour of ethics credit. It has also been approved for 1 hour real estate certification for attorneys. Please self-report this course number in the member portal. Again, 9320. You will receive an email tomorrow via Zoom outlining this information. I also encourage Florida Bar members and Florida registered paralegals to take advantage of the Florida Lawyers Helpline, which is a completely confidential and free service which entitles you to 5 counseling sessions per year to help you develop strategies to overcome life's challenges, balance priorities, and better handle both personal and professional pressures. This concludes today's webinar. Thank you.